Please don't let me do it. Don't put me in residential. Don't. And I listen. We put you on probation. A month and a half later, you pick up a felony DWI. So all this. Go.
All right, folks. Here's the first major red flag. Probation given, then boom, a felony DWI. Barely 6 weeks later. Classic 2 steps forward, 3 steps back scenario. But let's pause. Why is the GPS device acting up? Could this charging issued be a convenient glitch or a sign of deliberate tampering? And here's a legal nugget. Failing to maintain your GPS monitor properly can be treated as a violation, just like stepping outside your approved boundaries. What do you think? Accident or excuse? Drop your theories below.
Acting.
I heard that.
Okay, Dustin.
So, one issue as far as the GPS monitor and all that, they gave him a new device just now. They said it was a charging issue. They plugged it in, it would charge for 10 minutes, stop charging. He has a brand new one they just put on this morning. Now, the drug test
violation that he's out at 3 a.m.
Well, no, it's not that he's out, is that's when it reconnected. So but they gave him a brand new device. So and they're saying there was an issue where they changed the device out and there's not a tamper on it. It's just, it said it was not receiving. It didn't say it was that he was out and about. It said it wasn't receiving, and they started receiving again. That's at least the report that I saw. It's not like they were tracking him other places. But as far as resolution of the case, I did talk to him, and he is interested in participating in DWI court. And because we talked about that last week, and I had visited with him on that this morning.
Says here on 3/11/24, GPS device generated a failed to enter alert at 10:15 p.m. At 11:46 through 3:02, GPS device was in no GPS no cell status and was unable to be monitored during the time frame. Client arrived home at 3:01 a.m. on 3/12.
So that's not when it arrived home. That's when it started charging again. Because it's not a geolocate. I mean, as far as I'm understanding, it's the GPS shows where he is.
I'm going to be honest, Your Honor, that would be a question for pre-trial.
Oh no, I'm sorry. It's pointed to the client, not to you.
Okay, I was like,
Saying out and that he's out in the middle of the night.
I don't think they're saying that. What they're saying is that it's received a no signal.
Client arrived home at 3:01 a.m. on 3/12.
Where was he before that?
Huh?
They don't know where he was before that. He was at home. He just wasn't charging.
You have.
That's the way I'm reading it.
Do you have? Do you have the idea of where he is?
I don't see any notes from the case manager. And then at 10:05, I see on the report, it's showing that he's not at his home location. So I think that would be the fail to enter. And then there was the portable violations as well that were added. But again, from what we discussed earlier, I don't, necessarily have to go forward.
Portable the violation in what respect?
They sent an email yesterday from the supervisor that was here earlier, stating that there were additional.
Did Anthony send that?
No, it would be from Cody Pittman.
Okay, I see.
This specific one is from Luis Galvan.
Judge Jones is clearly fed up. I just don't get it, he says. And honestly, who can blame him? Skipping tests repeatedly isn't just disrespecting the court. It's a recipe for disaster. This isn't just about compliance. It's about public safety. When does leniency turn into enabling? Here's a question for the audience. At what point should the court start throwing the book? And when should they try rehab instead? Your call.
So I also have here, a client was also instructed to obtain a portable alcohol testing device, comply with all testing protocols, refrain from alcohol consumption, and comply with all routine equipment service. The defendant failed to provide breath samples, scheduled times, resulting in 13 skips from 2/7/25 to 3/17 of 25. So he's still skipping tests. Come up, Mr. Jones. I just don't get it. I truly don't. It's over and over and over. You are still skipping tests. And I don't know what it is and what I need to do to get you to comply with bond conditions. You're still skipping the test. I mean, I have no other choice. I now have to revoke your bond again.
All right, well, then let's do a plea then.
Huh?
Let's plea it.
I agree with, and I'm okay, but I'm gonna tell you now that I want to have him TRAS'd immediately to see how we go forward.
Well, Judge,
You know,
okay.
just all I want you to do is not kill anyone, man. That's all I want. You know, really, I'm not asking for much. You have since day one in our court have repeatedly refused to comply with bond conditions over and over and over.
And bam. The test results come in positive for THC, Suboxone, and Oxycodone. Now we're talking a serious cocktail of substances. That could impair judgment, the court's dilemma, punishment, or treatment. This moment perfectly captures the ongoing tension in drug-related cases. Do you incarcerate someone or attempt intervention first? Also, the judge's idea of tasing here is a wild but intriguing step, essentially using real-time drug monitoring to guide decisions. What do you think? Innovative or intrusive?
And I'm not doing a plea to where he can just get out and just do, and
So,
you scare me.
so how do we resolve, Judge?
Huh?
So how do we resolve it?
So, yeah, I agree with you. I think that the correct thing to do would be probation,
Okay.
but I would like to have him TRAS'd while he's in there. And I have a feeling I know what the TRAS is going to say, and that's what I would like to do.
Okay. I would request you to set a bond.
Of course.
It's just costing him money, Judge. All we're costing him is his family money.
So it's okay to just skip tests?
No, it's not. It's a test, but I'm saying
It's a skip. I might just be asleep, but I'm not trying to skip me wrong. I swear to God.
just stop talking. Yeah, you don't,
Sure.
just stop.
Okay, he goes, and it's literally, the minute he gets out, we have bond violations over and over and over. Now, what are we in now, day what?
So if the court wanted to be made aware of the presumptive results,
What did he test positive for?
THC, Suboxone, Oxy, and benzodiazepines.
You tested positive for Oxycodone?
Yes, Judge, presumptively positive, it's being sent to the lab for further testing.
What I had envisioned, what I think is probably do like a 2-year probation. I want to do like maybe 10 days as a condition, do an immediate TRAS. We'll get it done today, tomorrow, and we'll see what the TRAS says. And I'm going to go with what the TRAS says. If the TRAS says, and I promise you, Dustin, I will do what if the TRAS says that IOP, SOP is the proper course, then I'll do it.
Okay.
You know, but if they say residential, I think that's, I want to follow what the TRAS says because I think that's the proper course.
I don't think you can take it. I just don't think you'll take it if it's residential.
Then I have a jury waiting right now.
You see what I'm saying? I mean, let's just see what it says. Let's try to get a quick TRS done.
For sure.
How quickly?
So do you want to do the probation?
Yeah, he wants to do probation, Judge.
Okay, let's do it.
My new kid.
Okay, Blaze, you let me know.
On, is this
No.
on here?
Jones, probation.
Okay, yeah, I mean, we had offered the probation first, so, yeah, it's TRS.
So,
Okay,
probation,
2-year.
TRS conditions.
2-year.
Okay.
I want to do 10 days as a condition. That way I can get the TRAS done now immediately while he's in. And then I'm going to follow whatever the TRAS says. Are you Dad?
Yes,
How are you?
I'm fine.
Thank you so much for coming.
Yes. Can I say something?
First, go with Dustin first, because I don't want you to say something that really, just, just,
No.
please. Yeah, you guys can talk, and then later on, if it's, then,
Thank you, Judge.
thanks, Dustin. All right, come on up.
Yes,
All right, so what we're gonna do, Judge, is he's not gonna bond out. We're gonna reset it for she said she could get a TRS done in a couple days. I got him, but he wants to see what the TRS is gonna say if he recommends DWI court, because that's kind of what he wants to do. Pretty much I think he'd be more successful in DWI court. So let's get the TRS done.
In sober court, he just wants to be out, so he doesn't have to be in custody, but the problem
this
is,
is gonna be in your court.
it won't be in my court.
I understand that.
So
You guys see that done, but he's
This is a real courtroom showdown moment. The judge is making it clear, no more soft probation if the defendant won't follow the rules. Jury trial on deck and probation is off the table if the defendant rejects recommended treatment. This shows how judges can use the threat of harsher punishment as leverage to force compliance. It's a balancing act between justice and rehabilitation, and the stakes couldn't be higher.
He's not bonding out. Dad's not bonding him out. I told him he needs to sit and have TRS done, and they need it done. So I'm gonna reset us. What, 5 days? Tuesday? And let TRS by then. He's not gonna bond out because we're not bonding out.
You want to talk?
Yeah, I don't want him on. I suggest I don't want
I get it. I understand.
You know why.
I understand. I understand.
So, we'll do five reset for Tuesday next week, then they have TRS done by then.
Okay. All right.
Suggestions.
Okay.
And I'll get the.
So we're not doing a plea today, but hold on. Dustin, come on up. I want you to know that if it says residential treatment
Understand.
and he's no,
Asterisk shift gears to a brand new case. A hit and run involving a car dragging an aluminum polius. Really stuck on its hood. This scene paints a vivid picture of reckless driving, with property damage, and fleeing the scene.
How?
Notice how the officer is meticulous, interviewing witnesses and piecing together the timeline. From a legal standpoint, hit and run charges combined with possession of marijuana complicate things big time. How do you think these factors affect the severity of charges and potential plea deals?
I mean, I'm setting this case for trial,
Absolutely.
right? And I'm not gonna,
Are all full straight probation?
I understand.
Okay, cool. I heard it for.
No, he was asking.
No.
It's not legally possible.
my concern is that what I feel is gonna happen is when he does a TRAS, they're gonna say residential, and he's gonna say, I don't wanna do residential, I wanna be out. When we know, based on here, it just doesn't work when he's out. He does what he wants to do.
If he
To
doesn't,
hell with the
if
conditions.
he doesn't want what the TRS recommends, then he'll take a jail sentence, and that's just what it is.
I'm not gonna take that. I'm not taking it. I'll send him for trial. I'm not taking, no.
A jail sentence. Like,
You can do what you want,
he's
but
not probation eligible for a jury. You can't force that probation. Let's say the TRS.
no, I think I can. I mean, I think I can. I mean, I'll look the code, but
If I do jury punishment, you can't. Like, it's, you see what I'm saying? It's like, I do jury
I mean,
punishment,
sure.
you can't.
Sure.
But I'm not trying to. I'm just gonna TRS and see if we can get it to help, because you want, yeah.
Dustin,
I know what, dude, we're on the same.
giving him a jail sentence of 20 days, 30 days, 60 days solves nothing. It literally throws him out into the wolves, and he's just gonna pick up a felony DPI within the next 30 days, 60
Let's see what the
days.
TRS says and see what we can do.
I'm trying to help this kid, man.
I know you are.
And just a straight jail sentence it's within a year he'll have a felony DPI.
I understand. And you know I understand. You know where I'm going.
All right, so let's see what the TRAS says, and it's pointless in argument. I agree. Let's just see what the TRAS says. We'll have from there.
Is it, take your,
All right, good morning, Mr. Reynolds. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 10th, 2025, officers were patrolling the area of the 13,500th block of Beechnut Street, Harris County, Texas. And they observed a white Hyundai Kona with an aluminum pole stuck to its hood due to a recent crash. A traffic stop.
What?
A aluminum pole stuck to its hood.
An aluminum pole stuck to the hood of a car.
Yes, Judge.
That's the basis for the stop.
Yes.
Okay.
This is word for word what when I observed a white Hyundai Kona with aluminum pole stuck to its hood, comma, recent crash. I then got behind the vehicle and yeah, finished it. Yep.
Yeah, keep going, please.
Okay. I went back and got behind the vehicle. The officer started speaking with the defendant, who admitted to being driving and that he had crashed. The defendant told me that someone swerved into his lane and crashed into the pole. The defendant stated that he already called his record and that he was good to go. The defendant did not show any intentions of going back to the original scene and gave his information. While the officer was talking with the defendant, a security officer told the client that some people flagged him down the street saying that the defendant crashed into multiple parked vehicles and drove off. The officer detained the defendant and went back to the original scene, which was a quarter mile from where the officer found the defendant.
Now that adds to it. I mean, that's certainly,
The officer spoke with a witness who stated that he was by the front of the apartment when he saw the white vehicle losing control, crash into a pole, and kept on driving while hitting another two vehicles. The witness stated that he was going around 60 to 70 miles per hour in a 35 mile per hour speed limit zone. This confirmed how the aluminum light pole got stuck to his hood. The witness stated that he did not see anybody else around the vehicle before the incident. The officer spoke with one of the owners of the vehicles that was struck, and she stated that it will be around $200 to fix her vehicle and wants to pursue charges. The complainant of the other pickup vehicle had damages to the back right part of that vehicle, and the complainant stated that the defendant crashed into her vehicle and left without providing information. The defendant left the scene without, okay. At this point, they called intake, and then they completed an inventory search of the defendant's vehicle and located a black backpack with 7.4 grams of marijuana.
Now, here's the cold hard truth dropped by the judge. No license, no driving. Period. The judge's tone leaves zero wiggle room. I don't care if you need groceries is the kind of no-nonsense language that underlines how seriously courts treat unlicensed driving. This is a key reminder for viewers, even if you think your reasons are valid. The law doesn't bend on licensing and insurance. What's your take on strict versus compassionate enforcement here?
Multiple clear plastic bags and scale.
is he under arrest? I mean, if he's
Yeah,
under
so
arrest,
they
then,
called,
but I didn't hear that he's under arrest or anything. They just up and go start searching?
they did say that the officer called DA intake and spoke with an EDA who accepted charges of the FSGI. And then it states there was an inventory search conducted.
Okay, so they did arrest him but what happened? Because is there an FSGI charge?
We're gonna be honest, Your Honor, I'm not entirely sure what happened there. I'm working on it right now. If there's FSGI, right now I'm working on the complainants. We'll get things worked out that way.
I mean, I don't
Right now, we do
understand.
not have an FSGI charge at this very second.
Did they accept it or did they not accept?
Based on the DIM statement, it says that we accept the charges. So I am trying to see why there's not a charge, but it's not something that I know.
What a weird day so far.
Your Honor,
Can I say something? Your Honor?
No, don't. Now's not the time. I'm gonna give you a lawyer and you can tell your side to the lawyer, but,
I think there's a glitch in our internet system, so they can find marijuana, but they just, wherever, yeah, that's checked.
is it going to go through? Do you know?
I need to look into our system, our each, and figure out why it didn't, if portions of the works can be grand jury. But
So I'll give you, I guess, let's do this. I'm gonna appoint him a lawyer today and I'm gonna find probable cause for the moment, but I want to revisit it within the next couple of days to see what is going on. And then, all right, so I am gonna find probable cause for now, Mr. Reynolds. Can you look to see if he has a license, please?
Yes,
What is
Judge.
license? How old are you, Mr. Reynolds?
I'm 26, sir.
His driver's license is not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life. I don't care if you need groceries. I don't care if you need this, that. If you don't have a license and liability insurance, you're not allowed to drive. No, I will give you a lawyer today. You can say your side to the lawyer, but if you don't have a license and car insurance. You're not allowed to drive. Do you understand?
Yes, sir.
That is a condition of your bond. If I find that you do, I will revoke your bond, put you in jail, and no more PR bonds for you. So what I can have you do is I'm going to have Deputy Miranda give you an application. I'm going to have you fill it out. I'll have you talk to a lawyer today. But unless you, I guess let's do that. I'll have you talk to the lawyer and then we can revisit the situation after you talk to the lawyer. Please.